in 1988, the Anti-Drug Abuse Act of 1988 created the term aggravated felony and made it a part of the Immigration and Nationality Act. And at the time, the term aggravated felony was used to describe very serious crimes, and just a few of them: murder, drug trafficking crimes, significant trafficking and illegal arms and explosive devices. But what's happened with that act is those crimes have been expanded very, very significantly in the 1990 Immigration Act and the 1994 Technical Correction Bill, and then finally in the 1996 legislation, both the Anti-Terrorism and Effective Death Penalty Act of 1996 and the Illegal Immigration Reform and Immigrant Responsibility Act of 1996. And so what you have now is a term that's quite expansive, that covers relatively minor crimes, it covers crimes that could have occurred years in the past, and that for those crimes, people that are convicted of those crimes face automatic removal from the country. If people are unauthorized, they don't even go to immigration court. Anybody, including a lawful permanent resident that commits an aggravated felony, has no possibility of relief from removal. They face mandatory detention in the meantime, and they face a permanent bar on admission. And on top of that, there's no federal judicial review of those types of cases. So what started as a relatively straightforward category over the years evolved is to be this massive category of crimes that don't necessarily correspond to state crimes, that cover not just felonies but misdemeanors, and certainly not all of these crimes are aggravated either. And the consequences of committing any of these crimes is immense in terms of the effect on people and the immigrants themselves, which include lawful permanent residents and their families.